standing, and they will be resuming tomorrow morning at 9:30. Of course, we'll bring it to you live right here on Court TV. Let me bring back in my guest, Jamie White, a trial attorney and specializing in complex litigation and things of that nature. Jamie, you know, as I watch this case, I guess I want to get from you just overall, how difficult is it really to prosecute a case without a body? And why would prosecutors even bring a case without a body? Because when you talk about homicide, one of the elements is the fact that someone is dead. And if you can't prove that they're dead, that makes things very, very difficult.
You would think so. You know, as far as why prosecutors do this, we certainly have seen it done successfully before. This would not be the first time that there's been a prosecution without a body, but usually there is more extrinsic evidence, whether that's some evidence of purchasing of contraband, really explicit statements and evidence that there was some contemplation of violence or even murder before the person ended up missing. And, you know, here, you know, we just don't have that in any way, shape, or form. Again, you know, to my previous comments, I believe the defendant's behavior, at least what's been testified to so far, while maybe not the most congenial of folk, did seem to be one of a caregiver, whether it was tending to her medical needs, her mental health needs, which were obvious, and you know, just simple as going to work every day and being home for dinner. Now, whatever problems they had as a husband and wife that led him to allegedly step outside the bounds of the marriage, that certainly is not grounds for a prosecutor to find substantive evidence of someone's intent to kill. So, you know, I'm waiting for a shoe to drop, Michael. I know that at least in the pleadings, as I understand them and opening arguments, there's apparently some evidence that he made some statements to somebody or some people in jail. And we all know, you know, anybody that's practiced law, criminal law in particular, knows that the credibility of jail informants is questionable at best. But, you know, short of those presentations, I just don't see how they get there. You know, it's certainly not a 12-person unanimous verdict based on what we've seen so far.
Yeah, you know, one of the underpinnings, Jamie, of the prosecution's case is this idea that perhaps there was some domestic violence in this relationship, that he had been abusive to her. They're going to allow testimony from a wife and a child he had 30 years ago. They're going to testify to some domestic violence incidents there, which, you know, I'd love to get your opinion on allowing that in 30 years ago with no real direct evidence. But one of the things that I find interesting based on that theory is what wasn't said by the three children who testified. Stacey Deer yesterday, Wesley Edges, and Marsha Lawrence today. None of them testified to seeing anything like that. They lived with this man, they loved this man, clearly called him dad. And, you know, that's not, you know, unusual, but obviously, and as you said, it appears he wasn't the worst person in the world, took care of his family, took care of his wife for the most part. But they didn't say anything about any violence. So now I think when you bring in this other evidence of people that she apparently told he was violent towards her, I think it's going to undermine.
And to your first point, you know, I'm not aware, other than the motion to eliminate that was discussed quite a lot today, I'm not aware if there was any pretrial attempts to keep out this evidence of the prior alleged domestic violence incident, but it, in my opinion, is not relevant. It certainly is more prejudicial than relevant in the sense that it was so long ago that to present that to a jury and suggest that he was acting in conformity with that behavior 30 years later is just improper. So if it was argued and the judge did allow this in by way of a pretrial order, I think it probably sets up an appeal in the event this case goes differently than I think we all believe it's going. You know, there was some testimony, and again, the prosecutors appear to be offering these questions and wanting them to become evidence. You know, we see that sometimes on both sides of the aisle where, you know, you'll ask a question and hope that the jury kind of takes something from that. And the evidence that came in today to some degree was the testimony about the daughter walking into the room and mom was laying on a bed and had some blood on her shirt. And I guess the inference there is that he must have assaulted her despite the contradictory testimony that she had nosebleeds on a regular basis all of her life. And there was a similar incident in the hospital where she had just been based on new medications, where apparently they found her in some form of comatose state. But the witness goes on to say, Michael, that under cross-examination, she goes on to admit that she didn't call the police. She didn't have any real concerns other than, the health of her mother. There was never any attempt to inquire with her if she in fact was assaulted. And I think the question that really hit home for me was, if you really thought your mom had been assaulted to the point where she was out cold, why did you leave the residence? So this domestic violence theory, if you want to call it that, has been inferred, but to date, there has not been any evidence. And whatever comes in from 30 years ago, I just think that the jury is likely going to discount it.
No, you're absolutely right. And I thought the same thing when she was testifying about that incident. He actually brought it out that, hey, she then ended up leaving, right? So if you were so concerned about your mom, why did you end up leaving, right? And it's because she was trying to make it seem like it was this thing she was really concerned about. But, again, and the other thing I thought he did a masterful job of bringing out is the fact that, hey, you're all concerned about some of these things, but it's very different for someone who's living with this every day.
Correct.
The defendant is living with someone with mental health issues, and he's dealing with it day in and day out. Their response is clearly going to be different than your response when you're coming in every few months and you might see something going on. I thought that was a really strong point made by the defense.
Absolutely. Absolutely. And again, I've never lived under that, but I suspect if you talk to people that have, there's going to be levels of frustration. And, here this man stuck by this woman, stuck by this woman, stuck by this woman. And from his point of view, if you accept the evidence not proving itself, she disappears. I don't know how I would react, Michael. I don't know how you'd react, but I suspect some people would be resentful and would push back against any attempts to show her empathy at that point in time. Or at least maybe not forecast it in the way that others would. So, the prosecutors have their work cut out for them here. If I was her, I would be coming with the most generous plea deal that could be allowed under the law under these circumstances. I don't know what that looks like, but I think they're going to get handed a great big L if they don't figure something out here in a fast way.
Yeah, I would imagine that this defendant, based on the case that they have and based on his age, because he made some comments about any kind of sentence is almost a life sentence for a guy his age, especially with what's going on in the world right now. So he probably said, look, I'm not taking anything. I'm going to try my, best here with this case and roll the dice. That's right. All right, we're going to take a quick break. Jamie White, please stand by. It's always wonderful to talk to you. Right now, we're going to take that quick break. When we come back on the other side, we'll continue to break down what happened today in the case of Wisconsin versus James Prokopovitz. Stay with us here on Court TV.